Basically, my role today, yeah,
Yeah.
I think it's being recorded. So basically, my role today as the moderator is to introduce both of the speakers to all the participants. Now we have a very good number of participants. We have roughly 72, and I think more are coming. So we have with us today, we are so lucky, grateful to have with us today two distinguished speakers. Okay, let me introduce you to the first one. We have with us Professor Stefan Koos. He was born in Germany, so I have a long CV or profile of him here. Basically, he was attached to as a visiting professor to Universitas Islam Riau, Indonesia. So that explains why he has good command of languages. He is able to speak 5 languages altogether, okay, other than German. So he's fluent in English, Spanish, Indonesian, okay, as well as Portuguese. So that's a very advantage to have lots of languages. Okay, and then he has been writing a lot of publications here. Some of the latest publications by Professor Stefan here, I can see he has written on Introduction to Social Functional Approach, okay, in the Indonesian Consumer Protection Law. And also he has written on artificial intelligence, protection of personal data of citizens, and a lot more. It's a long list here. Okay, and then we'll move to the second speaker for today, which is Associate Professor Dr. Mohammad Tahir Sabit Haji Mohammad. So he's our colleague, our lecturer, okay, academic staff in AIKOL, Ahmad Ibrahim Kuliah of Laws. And then he has been entrusted to teach a number of subjects, including equity and trust, law of contract 1 and 2, Malaysian legal system, and he has been active in publishing articles, okay, journal articles. Some of the latest one, he has written on concept of valid contract declaration of wakaf property in Islamic law. He's also written on artificial intelligence, wakaf unit, precedence, and the role of analogy in common law, Islamic law. So it's a long list of publications as well. So we are so grateful to have two distinguished speakers with us today to share with us some of the some issues, okay, maybe to resolve or to give us some answers on the issues revolving around pandemic, which is COVID-19. Everybody knows about it. So the outbreak, okay, which the pandemic here has been declared, okay, by WHO as early as 12 March. So that's roughly 4 months back. Okay, and then with this MCO, movement control order, so it spurs, okay, it gives rise to so many legal issues, okay. So we are concerned about what happens to the contracts, okay, especially for those who are in businesses, okay, all those transactions. So basically, this webinar is hoped to be able to give us some solutions or answers, okay, on the impact of COVID-19, okay, what happened to the performance of the contract, okay, and then whether the contract should contain a force majeure clause or not, and what happens if there's no such clause, and what is the connection between force majeure and frustration. Okay, for everyone's information, actually frustration is one of the topics, okay, for syllabus for our law of contract. So it will be very much relevant to our students here. So most of the participants today are our students. So they are more interested to know. This is something which is beyond the lecture, beyond the things that we learn in the lectures or tutorials. So hopefully they can gain some benefits after listening to both speakers. So I don't want to prolong my introduction here. So basically, both speakers are given roughly 40 minutes to speak on the topic. I'll be the timekeeper as well. I will remind, okay, once the time is almost up, but we'll try to be flexible, okay, as flexi as possible. And of course, we are going to open a session for Q&A. So hopefully we can have some interesting questions. So now, without any further ado, I invite Professor Stefan Koos to explain or discuss, okay, or maybe enlighten us, okay, with the topic or the theme on pandemic, basically, okay, force majeure and pandemic. So the floor is yours, Prof. Stefan.
Yeah. Good morning, everyone. Thank you for coming to our presentations today. I am very happy, even if it's very early here. So I'm fresh enough, I hope now, So my presentation is a little bit rough. So because I started to think about that not long before, and I elaborated this presentation, which goes in its importance far over the pandemic special situation. It's rather a topic which is belonging to Mr. Bohnes and my plan to make a new style of law teaching here in Germany to our students, focusing more on maybe 7 or 6 to 7, 5 main topics of the civil law. Risk allocation. I will talk about this, and this will focus everything. And I found out that this is a good example for that. So I will try to make it not too scientifically, also to make it comprehensive for students. So the other point is I will talk from the point of view, of course, of the continental German law, which is not too much linked to the specific German situation, but more to the continental situation and also to the European Union situation. And of course, Malaysia is following the common law, so it will not be totally parallel, but the main principle also will fit, I think. So I will give now to my presentation. I hope it will work. You should see now my presentation.
Yes, we can see, Prof.
Maybe let's start with some with some remarks on which topics of which cases we talk here. I want to give you an insight of the solutions from two sides. One side is the individual contractual side, and the other side will be the legislative side. So the cases are in the pandemic. We had not a totally lockdown in Germany, but many shops which were not system relevant were closed for a certain time. So our measures were relatively liberal. People could go wherever they wanted. People did not have to show to the authorities whether they have a good reason to go out of the house or something like that, which we saw in different other countries. But a lot of shops were closed, like fitness centers and restaurants and bars, of course. And of course, these lockdown measurements led to the stop of income of many shop owners, and basically also a problem for the employment. In Germany, we have some instrument we call Kurzarbeit, short work. This means different than in United States, where we have more or less the hire and fire principle. Here, employees were not fired at once and are not fired at once, but they work maybe half the time. So they could keep the jobs, but of course, there were also economical problem for the employed people, and so there were economic problems, and the state was thinking about what can we do to lower the consequences of these lockdown measures. Here we start already to see we have a question of risk allocation, because of course this is also bound to the constitutional principle of the German state, which is the social state principle, which is more than just the freedom state principle or free economic principle, which is a side effect of the social state principle, is that we have to lower the consequences, the social consequences of certain situations due to the constitutional provisions. Now, these lockdown measurements lead to a specific problem to the long-term service contracts, of course, like fitness centers. People have a long-term contract and it could not be fulfilled. And the companies started to ask the customers for solidarity, not to take back the money, because basically they could take the money they already paid for the long term, and many of the people were solidaric and did not draw back the money from the contract. So I did, but of course not everyone. And the question was, can the government, by legislative measures, or can the law, the civil law, lead to a situation that the customers are maybe forced to be solidaric? Let's say like this. So we can think about moratoriums. This could be a measurement, so that people should not pay the contract until the end of the pandemic. And also the travel restrictions led to a lot of cancellations. And here the airlines, as you all know, were on the edge of bankrupt. Many airlines, big airlines, Singapore Airline, Turkish Airline, Lufthansa is now saved by the government. How can the law help in this situation? This is on the first side very clear. Of course, we must help the big companies which are employing the people, and this employment would be a social problem. And of course, the society must help here. But on the other side, we also must see that the people, the customer, also need the money. So it is already a question how we decide who should take the risk and how we distribute the risk in this situation. This is just an example, and I will focus later on this specific example of the airline cancellations. This has happened to me. Actually, I should be in Indonesia since half week already, because I booked already long ago in January a flight with Turkish, and Turkish canceled the flight from Istanbul to Jakarta. And I tried to get back the ticket costs, which I have a right to because of the European flight passengers regulation says that the airlines have to pay the ticket cost and the full cost of the ticket in case of cancellation within, I think, 10 days. You can imagine that is not happening. And in the case of Turkish, it is rather not amusing, because the Turkish was avoiding even to apply for a reimbursement. So you cannot apply. When you go to the web page of Turkish, there is the option to get miles, and there is the option to get a voucher or open ticket or whatever. But the option to reimburse the ticket cost was, now it's open again, but was for months closed. And I tried to get the money back, writing to Turkish. The fax number was not available. You have no German office who is processing this. So if you write to the German office, they say it's not our business, please write to Turkey. And of course, you can imagine if you write to Turkey, they will not come back much. Yeah. So until now, I don't have my 2,500 euro back from Turkish, which is a personal problem. But this is not only me. I read that alone German airline Lufthansa has $1 billion of debt to the customer because they did not pay yet the ticket cost. Now we can discuss that. I discussed with Professor Bono about that, and of course he understands also my point of view. But he also said, yeah, this is like this. Yeah, so pandemic is something unforeseeable, and we come back to that aspect of solidarity in the end. Now, what was the measurements of the government? So first of all, before we can talk about the measures of the government in the pandemic and about the question whether this special situation gives the right to contractual partners to not pay back or to not fulfill contract or to fulfill the contract later than it should be, we must talk about, and this is not a very difficult question, whether the COVID-19 pandemic is a force majeure issue. Yeah, we call it höhere Gewalt in the German law. Force majeure in the German court decision practice means extraordinary, unforeseeable external events affecting the performance of the contract, which cannot be prevented at all or in timely manner, even by applying the reasonability to be expected prudence and technical economic reasonable means. So the local court of Augsburg already qualified another epidemic, the SARS virus epidemic in China in 2002, 2003 as force majeure. And there is a lot of district court decisions which do similar to these kind of events. So the force majeure, different than as I know in the common law, is not a general principle, but it was developed by the legal science very early out of the bona fides principle. And we have some few examples where the force majeure is also integrated in the written law in the German civil court. We find it in paragraph 651H in the travel contract. It is a contract about a package travel, package trip contract. And if the trip cannot be processed due to force majeure, then the travel agency or the tour organizer does not have to fulfill the contract. So he's free of the contract even if the contract is done, and he can cancel the contract, but also the customer can cancel the contract in that situation. This is explicitly a case of force majeure, but it does not help us in the case of the question whether we can have a reimbursement of the cost, and whether the contract partner, in this case the airline or the trip package organizer, can keep the money or have to give the money back to the customer. This is not said here. It only says you can cancel the contract, and cancellation of the contract means you have to give back what you already paid. So the trip organizer must reimburse the cost because he did not fulfill the contract, but also there is no damage repair claim of the customer against the trip organizer. The problem is rather the adaptation of contractual duties and the change of legal duties we have in cases that contractual duties cannot be fulfilled. Now, the second step, the consequence, is there is two sides. The first side I want to focus on is legislative measures we had in Germany during the pandemic, and I will not go very deep into that. I just want to mention these measures and the most important aspect of these measures. The first one is the act to mitigate the consequences of the COVID-19 pandemic under civil insolvency and criminal proceeding law on March 27 of this year. It says in Article 240, Section 1, that consumers are entitled to refuse performance until no later than 30 June 2020, which is now due, of a claim in connection with a consumer contract, which is a continuous obligation and which was concluded before 8 March 2020, where, as a consequence of circumstances which can be attributed to the multiplication of infections caused by the SARS-CoV-2 virus, they would not be able to render performance without endangering their own decent livelihood or that of their dependents. This means, especially for contracts, private living contracts, housing contracts, that the payment of the rent can be postponed not longer than 30 June 2020. So which is of course linked only to consumers, not to business contracts. This is a clearly social measure to protect the payment ability of the consumers in this situation, and we see here clearly that the legislator made a decision about the risk allocation to the contractual partner who gives the living space to the private person, or to give the consumer the right, and the consumer has the right to postpone the payment. This is the first measure. The second was the act to mitigate the consequences of COVID-19 pandemic in the contract law of events, which is specific to events like concerts, reunions, theater, organized theater presentations, and all these cultural things, which give the customer the duty. And this is the most important now. This is what we have to think about carefully: the duty to accept a voucher for the event. So instead of being able to claim for a reimbursement of the cost for the entrance, the customer must accept a voucher for the case the event will be later done. which is not sure, and if it's not done after a certain time, then the customer still have the right to maybe get a reimbursement, but until then the company could be already insolvent. So the insolvency risk is on the customer in this case. And the government the federal government tried to make a similar solution for the airline, to make some act to mitigate the consequences for the airlines, giving the airlines the right to offer the customer a voucher for the ticket which is cancelled, and the customer has the duty to accept this voucher. This was not possible. I must say, good luck. It was not possible because the right of the customer to get reimbursement of ticket costs is regulated in a European regulation of passengers' rights, and the European regulation of passengers' rights already harmonized everything which is connected to the passenger's right of reimbursement and damage repair for cancellation or delays. So the government has not the right to make an autonomous national solution to this issue, and so we don't have this this act in the German law, and basically the customer has still the right to get reimbursement from the airline if this is done. But the problem is rather now a factual problem that the airlines just don't pay. If we talk about this, especially this act of mitigation, which gives the customer the duty to accept the voucher, then we see something very interesting from the point of view of the civil law and of the contractual law. We see that a certain contractual equilibrium coming from the private autonomy is actually changed ex tunc, retroactively by a legislative measurement. So the legislator says you don't have as a customer the right to claim for a reimbursement now because of the pandemic, but we see that the right to claim a reimbursement is a part of the equivalence of the contractual partners, which is done in the time when the contract was done. So what we see here is a retroactive or retrospective legislative change of the equilibrium between the customer and the company. And this is problematic. We should analyze why. So first of all, in the civil law, the aspect of the retroactive and retrospective legislative changes is not so much discussed like in the public law. In the public law, of course, we have a more sensitive aspect here because of the situation of the relation between state and citizen. Here we have a relation between customer or between two contractual partners. And first of all, generally, we must differentiate between retroactive effects and retrospective effects. So if we talk about long-term contracts like fitness center contracts or hiring contracts or something like this, then we have rather retrospective effects which are not so problematic. A legislative rule affects current, not yet completed facts and legal relationships for the future and thus immediately invalidates the legal position concerned. This is not totally unproblematic, but this is less problematic than the retroactive effect, which changes and subsequently intervenes in already processed facts belonging to the past. Now, if we talk about flight contracts or travel package contracts, we see it's not yet totally processed, so because of the reimbursement, but actually it's processed because there is no fulfillment on the contract anymore, and there's already the decision that there will not be a fulfillment anymore. So it is very clear the equivalence between the contractual partner will not be the one which was planned when the contractual partner made the contract. So I would rather say this is a sort of a retroactive effect, at least not totally retrospective effect. And we must think about what does that mean for the legality of of these measures. Now, we have here a general problem which is very, very few discussed in the moment in the German literature. It is started to discuss, but even in the ministry, they did not see this problem. It's a general problem of legislative interference in the private autonomy. Because the right of the customer to get a reimbursement in case of not fulfillment of the contract is, of course, the consequence of the private autonomy and of the equilibriums the contractual partner did. And this is a fairness principle. Now we have in the civil law no general prohibition of legislative retroactive effects. In the criminal law and in the public law it's different, but in the civil law it is very, very few discussed. If the duties are still active, we have an artificial retrospective active, we already mentioned that. If it's already done, we must think about whether we can accept that legislative actions can interfere into the private autonomy. And this is a question also of the constitutional law, as we will see. But first of all, we must, if we see it in the background, legislative action should never be seen without thinking about the background, the social background and the economical background. This is always a decision of risk distribution. And the risk distribution here is a decision of bona fides and of what the contractual partner in the society can await. So this is generally spoken, actually the main point about all this. Should the government give the risk to one of the contractual partners or the other, or to the society? And from this is depending which legislative actions are to be awaited and which legislative actions are fair, because we must see that also in the light of the fundamental right of the contractual partners to private autonomy, to foreseeable legislative actions, and also to the property fundamental right. Preferable, in my opinion, would be a solution which is flexible, doing it with the instrument of the disturbance of the basis of the transaction, and not by legislative measurements, which are very unflexible and which are not taking into account the maybe different risk allocation aspects of different contracts. The basic methodic problem is, can legislation change a contractual equilibration retroactively? And this is a constitutional law problem. As I mentioned before, we have the private autonomy, and the private autonomy is by many of my students seen also only as an instrument of the civil law, and they don't see the constitutional aspect of the private autonomy, which should not be undervalued. When we talk about the artificial intelligence aspect and about artificial intelligence contracting, then many people are very open for that. If we have intelligent algorithms who can make smart contracts or can make contracting all alone without any influence of the people, I talked about that in last year in your university also, then we give up a very important principle, the principle of freedom in the contract. The principle of freedom in the contract is not fulfilled if algorithms, determined algorithms make contracts. The principle of freedom is in the private autonomy, and the private autonomy is an instrument for personal freedom. As an instrument for personal freedom, it is clear that the private autonomy has its basis in the constitutional law, in the personal freedom, basic right of the personal freedom of citizens, in the use of the subjective right of the individual. The subjective right in the civil law is also not just an instrument of some separated aspect of the law, separated from the constitutional law, but it is the subjective right is an instrument for personal freedom. So the first point is, if the legislative action is influencing in a way the equilibration of the contracts retroactively, this is a retroactive influencing of personal freedom of the private autonomy. And this is basically also, from that point of view, a constitutional law problem. The second aspect is, we have the constitutional guarantee of property in the German constitution, is Article 14.1, which not only contains the protection of the property in the classic way, but also every legal position which is comparable to property. So, for example, is the shareholder interest can be one of these aspects of the property, but also the ownership of a claim, which is already given by the law to a contractual partner, is part of property. So if the government or the legislator taking away this right of the customer to reimburse cost of he already paid because of a contract he has done before, then this is a suspension of a legal position of the customer, which is contained by the guarantee of property. So from this aspect, we have a clearly constitutional problem. And in all cases, when we have a touching of the constitutional fundamental rights, we also must talk about inherent limits and restrictions of the fundamental rights. And if we think about how we should bring this pandemic thing into this constitutional system, then we can say it could be a part of the inherent limitations and the inherent restrictions of the fundamental rights. So we have to think about whether the government or the legislator can make this as an inherent legal restriction to the fundamental right of personal freedom of the citizen and of the property fundamental right. And this can only be decided after an equilibration of reasonability for the customer in the light of the special situation of the pandemic and of a reasonable allocation of risks. So we cannot say this basically it is okay or it's not okay. We must analyze how the allocation of the risk should be here and what the contractual partner could await in that situation and who should take over the risk. And the last constitutional aspect we have to mention is the principle of the protection of legal expectations and the legal certainty, which is a very important aspect of the rule of law. The legal certainty and the legal expectations of the customer that they will get their money back in case of a cession of the contract and in case of not fulfillment of the contract is here not fulfilled. This expectation is not fulfilled. And what think about is this constitutional legal. This was the legislative aspect. If we come to the more individual contractual aspect, then we have a parallel problem. We can talk about the cession of adaptation of the contractual duties by the instrument of seizing or disturbance to exist of the basis of the transaction. This is comparable to the clausula rebus sic stantibus in the Roman law. As a contrapart of the limit of pacta sunt servanda, contracts are to be fulfilled, but in certain cases, they don't have to be fulfilled. And in the civil law, in the German civil law, this is not a general institution. The clausula rebus sic stantibus was, in the general opinion of the German law, was never a general principle, but it was developed by the legal science from the principle of good faith. So this is one of the most famous examples for when this was developed. The German hyperinflation in 1922, 1923, you see it's very interesting. These are original photos. The money was in a very short time so worthless that it was better to fire the money to get warmth from the firing the bills than to wait until the money lose more value. So you see 100 billion mark. In the end, we had, of course, a reform of the money. In this case, within days, within hours, the value of the money changed, and so the equilibrating situation between the contractual partner changed totally. And this was a good example for this institution, which we have now in our civil code in section 313. If circumstances which became the basis of a contract have significantly changed since the contract was entered into, and if the parties would not have entered into the contract or would have entered into it with different content, if they had foreseen this change, adoption of the contract may be demanded to the extent that, taking account of all the circumstances of the specific case, in particular the contractual statutory distribution of risk, one of the parties cannot reasonably be expected to uphold the contract without alteration. And the important thing is that here are two steps. One step is to cease the contract in the case it cannot be adapted anymore. And the other step is to adapt the contract to the new situation. And I always tell my students it is very, very easy to apply Section 242, the bona fides principle, and Section 313, the interference with the basis of the transaction. But it must be applied very carefully, because it must be always analyzed which is the awaited situation and which is the risk allocation in the certain case. Because we cannot give the risk allocation to one partner without having this analysis, because the law says, and the general principle already says, it's very important here, cannot reasonably be expected to uphold the contract. Yeah. So if we see the system behind that, then it's very clear that this principle is a aspect of equivalence justice. The equivalence justice, which was the basis of the contract when the contract was done, is changed by a new unforeseeable situation, which is very drastically changing everything, and the other partner has to accept this, because it is a question of equivalence justice, of fairness, to accept that in the interest also of the other contractual partner. So this is a question of risk allocation, because what is just is a question of what is the just risk allocation. So who has to take the risk of, if we apply it to the pandemic, of financial problems of the contractual partner because of the pandemic? There is three cases, or the debtor has to take the risk, or the creditor has to take the risk, or the society has to take the risk. And this is what I said in the beginning. When I will give this lecture to my students, I will tell them it is all about risk allocation. This is every time the same. It's all about risk allocation. Many of the issues we have in the civil law, we can reduce to these questions. Yeah, about due diligence and all these things is all risk allocation. So one thing is clear: the society can take risks if the society thinks we must be solidaric in a sort of a collective solidarity, but this cannot be by distributing a specific contractual risk to the debtor or the creditor. If the society wants to take the risk, that should be public finance support. So it is already very clear that cannot be done by a contractual system or by a contractual instrument like the cession of the basis of the contract. It is not so easy to say whether the debtor in the pandemic or the creditor in the pandemic should take the risk. If we analyze and apply this risk allocation test, then we can maybe say that the change of contractual duties in the business lease agreement this is a business risk, that something could happen, something unforeseeable, and we cannot say that just because of a business lease agreement, the owner of the property cannot get any payment anymore. It's very easy it's not easy to say that one part or the other part should take the risk full. So I'm of the opinion here we have a clear risk, which is a business risk, which should be given to the party, and we have no change of the basis of the contract. The same will, in my opinion, happen to the private residential lease agreement. So I don't think it's acceptable that the owner of the property will not get the money at all anymore, and the resident can keep the money forever. But if we talk about the moratorium, which is a part of the legislative measurement of the government in Germany, then we can say that a moratorium, a postponement of the payment in lease contracts can be fair if it's not the basis in EU law, because the EU law make a different risk distribution and give the risk totally to the company. So in the airline case, there is a clear decision risk distribution to the company. Now, what is the basic risk distribution in the special case of retroactive change of legal rights in the case of these ticket costs? Or general in the contract law, in the German contract law, we have the section 326, which says if the contract cannot be fulfilled there is no possibility to fulfill the contract objectively or subjectively, independent of the claim for damage, which is of course only given if the non-fulfillment is the guilt of one of the contractual partners. The debtor, the obligor, is not obliged to perform. So basically, if due to pandemic or other aspects, the contract cannot be fulfilled and there is impossibility to fulfill the contract, the law give already the risk allocation to the company and says to the company, you must pay the money back. It is very clear. If there's no duty to pay, of course, there's also the right to get a reimbursement. So we have already a certain risk allocation and a certain decision by the law, by the civil law in this section 326. And the special case in this flight ticket and travel contract is can this duty to reimburse, which is already a decision of the law, can this be switched off, yeah, by a legislative retroactive suspension of reimbursement by this act of for mitigation of the results of the pandemic. And this is a different question than to ask about, can the contractual partner postpone the payment or can the contractual partner stop the payment? It is a question which is already actually decided in the contract law. And the contract law says if there is no performance, then there is no counter performance. Now, if we want to decide this, we must think about the fair risk allocation between seller and customer. And we must say that here the customer is same weak as the seller. So from the fairness question, we cannot just say the seller has the right, a company like German airline Lufthansa has the right to not reimburse the cost and force the customer into vouchers also, because it is not a clear decision about the risk allocation. It is actually an entrepreneur risk which should be taken over by the company. The other question is a moratorium which may be conform, also vouchers which can be monetized after some time. Here we talk about the risk of insolvency which is given to the customer, which is of course a certain risk, but we can discuss that. But a suspension of the reimbursement in general is not acceptable, and so it's not a clear risk allocation. So we come to the conclusion that make it maybe a little bit more clear. The retroactive change of the sorry, I made myself a reminder that should not be so long. The retroactive change of the contractual and post-contractual duties of the contract partners by the legislator can infringe the fundamental right of property and the rule of law, and is also a strong extunct intrusion into the private autonomy. This is first. Second, payment moratoriums and extensions of the reimbursement period could be within the limits of the fundamental right. If we see the risk allocation and if we accept that the customer also have a certain risk that the contract cannot be fulfilled, and there is a social risk which is belonging generally to the whole society, then we can say, okay, it is of course touching the fundamental right of property and the fundamental right of personal freedom in the aspect of the private autonomy, but it is within the inherent limits of the fundamental right. It is has to be analyzed whether it is equilibrated. Of course, inherent limits must be always equilibrated, so it must be carefully analyzed whether the pandemic situation is strong enough to say that we have a limit here. In my opinion, it is the case, at least it was the case in this time. And second, how long the pandemic is strong enough. It should be always, of course, checked whether it is still strong enough. And the risk allocation, if we decide the risk allocation is fair, if the customer only have the risk of a certain insolvency risk or something like this, a moratorium, then we say this is a fair risk allocation, and then it is within the inherent limits of the fundamental right. So it should not be a constitutional problem in the end. The suspension of the right to payment or the right to be reimbursed, in my opinion, is out of the acceptable limits of the property right. It is a wrong in unilateral risk allocation to the creditor, at least as long as the measures are not carefully analyzed from the point of view of this risk allocation and these economical results to the customer and to the company. So, in my opinion, as this is not the right, is a wrong unilateral risk allocation, it is not possible by the legislator, by the instrument of retroactive change to the private autonomy. It is not within the limits because the wrong risk allocation is not the right risk allocation, so it cannot be within the limits. So if it's done by the legislator, this is an infringement of the fundamental rights we mentioned here. But if it is in the contract law, then it cannot be done either in the disturbance of the basis of the transaction, because it is not the right risk allocation, which has always to be analyzed in this instrument of the civil law, different to the moratorium. Now, if we come to the end, how about solidarity in the pandemic? Which is politically, of course, always discussed is, okay, this may be the law, this may be the contract law, this may be the public law here, the government does this and the government does that, but in the end, many people, even colleagues of mine, which are law colleagues, ask me, yeah, but there is solidarity aspect. We should be solidaric. Pandemic is hitting us all. We should be all solidaric. This is a main topic. We can make a presentation alone about that in legal ethics. The question of solidaric, and this is a big question also in Indonesia and India and so on about this private public responsibility or the responsibility of companies, which should be in the solidarity to the society and all, and this. And India and Indonesia, as I know, Malaysia, I don't know, have legal provisions on this solidarity and on this responsibility. And I always, when I discuss it, say responsibility and solidarity is individual and cannot be forced by the legislator. So if you make it free, whether you want to be solidaric, you make a law which says that you should do this and you should do that in the light of solidarity, then it will not be fulfilled. Then it is free. Then it can be solidaric, but it will not help. But if you make it compulsive and you make a fine if not solidaric, then it's not solidarity. So we must differentiate between solidarity, which is individual, which is not the issue here, and the solidarity, which is a collective solidarity, which we can think about. If we talk about collective solidarity, then the law given by the legislator or given in certain acts also by the government cannot give the collective solidarity to one contractual partner alone. This is not collective solidarity. If the government or the legislator want to have a solidarity and want to give the risk to the society as a whole, then it can be supported by public finance measures. So, for example, in the labor law, if there is a stop of the labor contract, then there should be social measurements to the unemployed people. If the government decided to give the risk of the pandemic of, let's say, an example, airlines to the society, then it should, and that is happening in Germany, then it should support the airline. But it cannot say we give the risk to the society by giving the risk to the individual customer. So this is, in my opinion, the wrong approach for solidarity. So in my opinion, we should not use the contract law to find solidarity and to find a collective solidarity by giving the allocation to the society. Because in the end, the contract law can only give the risk to one of the contractual partner or to both of the contractual partner, but not to the society as a whole. So bilateral risk allocation is the issue of the contract law in the light of the contractual win, the equivalence justice. And here we saw already, it's very difficult to decide whether we should give the contractual risk by the pandemic to the customer or to the company. It is very difficult to decide in the case, for example, of the airline. There is no reason to say the airline should not have the risk. The customer should have the risk to not get the money for the ticket back, because in the airline we have so many unemployed people later if the airline go bankrupt. This is social risk and social collective solidarity, which is given to one contractual partner, which is, in my opinion, not the right instrument for it. So unilateral allocation of full pandemic risk to the customer out of the insolvency law, which already give a certain risk allocation. Yeah, the insolvency law says if the company go bankrupt, then the customer, even if he's the creditor, will not get the money back. Maybe if there's not enough. This is already a risk allocation. Yeah. Over this risk allocation, I think it cannot be done by
sorry for interrupting. You have roughly 2 minutes. Can you?
Yeah, I'm ready. I'm ready. This is the last I want to say. It cannot be done by the contractual law. And if we talk about the bona fides principle, it is also not the right instrument, because it is not bona fides that the customer cannot await the reimbursement of his costs. So you see, in the end, this whole topic is going far over the question of the pandemic. The pandemic is just a paradigm for a risk allocation issue, but a very interesting paradigm, because it is belonging to these very interesting legislative actions we have in Germany. I think you have maybe something similar there. And due to the high agreement of the society, with, in the beginning at least, with the pandemic measures, there was a high grade of solidarity in the society and in the citizens, and not many people asked about this. Yeah, of course, we must be solidaric. I also did not take back the reimbursement of my fitness center. Until now, you don't use it, but I don't take the money back, because I think all the poor employees of this fitness center. But it is not so easy to say, give solidarity by changing the contractual equilibrium. If the state wants to make solidarity, this can be only a collective solidarity, and then must be public finance measures in the social state principle, fiscal measurements, and so on and so on and so on. In the rest, we must always see the single case and must decide whether here it is foreseeable and the risk should be to the one side or to the other side, which is the risk. So normally we would allocate the risk to the party who has better chance. The chances of the party is to make a profit. If the profit is, let's say in the labor law, the employer has the chance to make profit, so he has the risk of that his company cannot produce anymore due to some outer aspects like pandemic. So if the company has to close, and that does not mean that he can fire the employees, because the risk allocation is here the entrepreneur risk to the employer. Thank you very much for your attention, and I hope we can discuss later this. It's very clear to me this is not yet totally elaborated, and also the equilibrium, whether we want to give the risk to one party, to another party, or the society, can be surely discussed, and it is depending also on the point of view. And I'm sure in the common law there is maybe other instruments we can apply here. Thank you very much for your attention.
Thanks a lot, Prof. Stefan. It was very, very interesting, enlightening lecture. Especially, you managed to draw our attention when you share with us about the flight cancellation. I think many of us are having similar problems here. Even in Malaysia, for example, my own experience, my flight was cancelled, and it's very hard to get the flight credit. They are not going to give you a cash refund anyway, as far as AirAsia is concerned. But for Singapore Airlines, they allow us to adjourn or to postpone our travel until next year. So because I'm supposed to travel to Korea and Japan this year, but both are cancelled because of pandemic. And then you also discuss about the definition and interpretation of force majeure in Germany. I think in Malaysia it's not that clear, but we'll see how it goes. Okay? Dr. Tahir will discuss about that. And then also the consequences. You mentioned about legislative measures, okay, which is meant to protect consumers, okay, in Germany, which is good. So in Malaysia, we don't have any specific legislative measure as yet, but government is taking care of to protect all the citizens, including all the consumers, basically. And you conclude actually with solidarity. I think, at least for me, it's something which is new. Okay, we are not really exposed to that particular point of law, okay, which is very interesting, individual or even collective solidarity. Okay, so now we want to move to Malaysian perspective, okay, local perspective, which is will be shared, okay, enlightened by our next speaker, which is Dr. Tahir. So Dr. Tahir, are you ready? Now the session is yours. So please, make us, we'll be mesmerized, okay, with your lectures as usual, your smiley face as well. So the floor is yours.
Okay. Okay, Assalamu alaikum wa rahmatullahi wa barakatuh. Can you hear me?
Yes.
Yes, sir.
Yes, yes.
But your video, what are you seeing? I mean, the video is not facing towards us. The camera.
Okay.
Yeah.
That's why I'm between on and off on camera, because my computer is a Chinese computer and it has unusual place for the camera. So that is the problem. Okay. Assalamu alaikum wa rahmatullahi wa barakatuh. Good morning to everyone. And thank you very much to the guest speaker. It was very enlightening. You learn few things from the speaker on German law, and I find it very interesting. Somehow I think the law in Germany and the law in Middle East or Islamic law is a little bit closer. They are on the same page. They are looking at the risk allocation or the prevention of loss to one party. And they are looking at the fairness to both parties rather than one parties. So that is quite interesting compared to French civil law and all those other jurisdictions which follow the French code of obligations. So my lecture is a little bit dull, not as much as previous speakers was very lively. And the reason is because Germany is one of those countries which were very proactive and which came with some legislative measures at the very early stage, based on which the risk was somehow distributed between the employer and the employee and the contracting parties. So whatever how the risk is distributed, whether it is fair or not fair, whether it is based on the solidarity or based on the consumerism, whether it is paying attention to the needs of the society, that is, I think, a matter for individual scholars to debate. But generally, compared to the common law jurisdiction, they were very proactive. Perhaps in common law jurisdiction, the only country which I can think is the Singapore, which came with some which came with some proactive legislation which could be used as a guideline for the business community. In Malaysia, however, we had some guideline issued by the ministry, but those guidelines were generally the interpretation of employment law. Generally, as we know, the contractual law is not only limited to the employment law, it is rather than in every area. You can go to the financial markets, you can go to the real estate markets, and most of the risky area is perhaps those areas. In the financial market, perhaps the risk of losing market value of the company shares would be the issue in case of real estate, because it depends on the you know, it's much not only a matter of employment, but it is also a matter of delayed work to be done by the contractors. And of course, each time someone delays work, it costs. So whether the law is, contractual law is sufficient or not sufficient, it is a matter to be decided later on. At the moment, we don't have very precise, direct legislation from the government in this country to give us a clear opinion. And perhaps this was the reason I did not include in my discussion what has to be done. Because we, at the moment, we are looking at the system of common law and Malaysian law. In common law, perhaps the law is, because it is developed through the judicial system, judicial decisions, and Malaysian law, we are having the Contract Act, which is can be used as a guideline, and expectation is that the court have to follow that strictly. So now, whether the law is clear on this matter or not clear, that would be, that was the main concern for me, and perhaps for that reason, my slides, which I will present later on, they would be just a matter of guidance or matter of principle that can be used by judges, by lawyers, whenever they want to think about the allocation of risk, or whether the arrangement should be done fairly or not fairly. And the most important thing here is whether the COVID-19 can come under the force majeure, or can it be considered as one of the factors for frustration of contract. So my main topic is on the issues, and perhaps when we look at the civil law, or when we look at the common law, or even in Malaysian law, which is following mostly the common law decision, despite the restriction on the importing of common law principles under the Civil Law Act, but the trend is still following the common law. So when we look at those decisions are not always clear. And it will be, common law is always a fluid law. It develops from time to time, and perhaps in this course of development, sometime there could be inconsistency, there could be sometime some negligence on part of the fairness. That would be the thing that I have to, I was considering, and perhaps because it is just a matter of opinion, I was not very much brave to write something. Perhaps I was discouraged by a piece of writing I wanted to publish in newspaper, and they went into, there is a missing in action so far. So, now when we look at the not so much clarity or rather than ambiguity on the common law, in the common law on the force majeure, i.e. frustration, we have to do some of those ideas. Now, before we go into that matter, under the common law and perhaps under the civil law in Europe, there are two choices. Choices are given to the parties, whether they want to allocate risk in an early stage during the drafting of the contract, or they have to wait for the pandemic or some unexpected event to happen. So for those who are very cautious, perhaps the big companies, they will have fixed clause in their contract. Normally, they call it force majeure clause. This will be negotiated normally between the parties, based on which we can allocate their risks, and based on which one of the parties can have the option to walk away from the contract, in other words, terminate contract unilaterally. That would be an excuse for unilateral termination of the contract. But the problem is looking at the financial markets nowadays and look at the expediency of the contract. Sometimes those terms are not negotiated well. It is just take and leave it or take it. So now that issue in relation to the clauses is a problem in, I think, in European law. But there is a kind of alternative in English law where the choice is not given to the parties to determine whether a certain event can be classified as a force majeure or not, or the impossibility of the performance. So in the financial market, this one is negotiated between several parties in England, and after the decision of that parties, which are considered to be third parties, then the contract could be, the event could be classified as one falling under the doctrine of frustration. So, but in case someone is not very cautious in the beginning and they leave the matter to the later events, then the operation of law will come in, and then under English law, the force majeure will apply. The civil law also, in the civil law, the force majeure will be applicable in the doctrine of force majeure, and in English law and common law or Malaysian law, the frustration doctrine will be applicable. Now, under Islamic law, mostly if we have some students from Middle East, the concept of the Islamic law concept of uzr and darar. Uzr means excuse, and the concept of darar, that is the risk or loss to someone, that is more prominent. And this is where I learned from the previous speaker that the common ground between German law and Islamic law, when they are looking at the both parties and they are looking at the equilibrium of contractual equilibrium, equality between the both parties, the risk should not be allocated only to one party. It should be shared between the parties. So these are the things that I'm going to discuss after this. But I'm looking at force majeure under civil law, perhaps because this one is the oldest principle under the Roman law, which was later on adopted by the French Code of 1803, I presume, quite 60 years earlier than common law. Now, under the French law, the French Code of Napoleon, the statement is that no claim for damages arises where debtor was prevented from transferring or from doing that to which he was bound or did what was forbidden to him by reason of force majeure or unexpected event. So now this principle under Article 1148 of the French Civil Code is followed by several jurisdictions, and it is very common in Middle East countries also. They are following the French Code whenever they have designed their own local law. So now, if you look at the force majeure elements, there are three elements. There are three elements under the force majeure according to the French law. The event that can be excused for termination of contract should be external, which is beyond the control of the promisor, and it should be unforeseeable. And the third one is irresistible. Irresistible means that there could be no precaution for it. No measure can be taken against prevention of such an event. So these are the three principle or three elements of force majeure under the French version of civil law. And normally act of God, act of war, and legal prohibitions are included in this promise, what do you call it, force majeure. So now, according to some scholars, externality beyond the control of promissories not often treated substantive. The externality can be subjected to other two conditions, that is unforeseeability and the irresistibility. So one or two of those two elements, if they are present in the case, that would be that the court can decide whether the event falls under the force majeure or not. But according to the opinion of the scholars, the practice is not uniform. Sometimes there you can find some inconsistency in the decision of the courts. Yeah. So in general, the idea of force majeure under the French version is punitive, or it is if someone doesn't fulfill his part of the obligation, then and it does not fall under the force majeure, which is subject to the three conditions of externality, unforeseeability or unforeseeability, and irresistibility. Then the party who did not perform his obligation could be subjected to compensation and all those things. So it is a kind of a punitive measure, and the law is a little bit strict on that part, and accordingly some of the measures may not fit within the definition of the force majeure. So and here the problem is certain times is Professor just now mentioned that the equilibrium or contractual equilibrium may be lost is here, because if on one hand it is difficult to bring the matter within the definition of force majeure, and you exclude certain event which was in fact somehow within not within the control of the party who did not perform the obligation, or it was not within their diligence. The problem is, you know, the diligence, because the foreseeability is subjected to the diligence of the party. Now, in certain cases, not everyone can be able to fulfill his part of diligence. He may not be able to spend enough money to inquire, enough to get all the information and to come up with a precaution. So it is, if you look at the principle of force majeure, it is a kind of conceptual or principalistic or jurisdictional thing. Because and somehow this one is the matter is a kind of a psychiatric. So what was in the mind of the parties, you know, what was not and should have been in their mind or not. This is a kind of, you know, you are subjecting the parties to their mental capabilities, but you know, not looking at the actual consequence of the event as a result of which someone may suffer. So this is perhaps a point which the German scholars perhaps may have more ideas on this topic. Now, in common law, as I mentioned, the force majeure principle is a very old, and it was under the Roman law. Then later on, which was codified by the French code. The theory of force majeure has not been has not been established in common law for a long time. It was established perhaps 60 years later, after the French code was made. And this one was made in the Taylor versus Caldwell. Now in this one, which was followed later on by other cases of the coronation cases. Now this, the contract law in England is having some kind of similarities between civil law and Islamic law in a sense. If you look at the decision of the Taylor, the court came up with the implied term of the contract that both parties should be able to deliver what they want to promise. So, and if that contract, that term of contract is unfulfillable, then because of some event and impossibility of delivering the performance, then the party will be excused. So so the theory of frustration is related to based on the force majeure under the civil law. So they have not looked at the event, they look at the delivery of the subject matter rather than. So the delivery of subject matter, then they say if it was possible, it was impossible, then it can be an excuse for non-performance of the contract by the promisor. But if it is not impossible, then it cannot be an excuse. So perhaps the frustration theory in that sense is kind of a diversion from the force majeure, and it has the similarity with the Islamic law on that point. So the theory of frustration, if you look at the history of common law, perhaps the principles of externality, impossibility, enforceability, or unpredictability, and controllability. Sorry, that was a mistake in my slide. Uncontrollability or resistibility are there, and this one is based on the analysis of a scholar in 1943. Who look at the frustration of contract, and he came up with those elements. He give opinion that all this, the frustration theory or doctrine of contract is based on these elements. So, and the impossibility of performance was in the case of a Taylor, and later on in the coronation case. This one is was for, the impossibility was there for quite some time. And then later on in 1956, they have came up with a different idea of radically different, performance if something happens. And because of the supervening event, if the performance is expected to be, the obligation under the contract is expected to be performed, the performance would be so radically different from the original undertaking by the contract that it will not be the same. So this radical change or radical difference of performance was added to the original idea of impossibility of delivering the subject matter or performance of the promise. This can we say showed that the latest change by the Davis Contractors Limited case changed the rigidity of common law to make it available in cases where it is not impossible, it is possible to do or to perform the promise, but at the end of performance, the outcome should not be so different from the original promise. So if the outcome of the performance is not different, then the contract would be enforceable. But if the outcome is radically changed, then the contract would be unenforceable, and it will come up with it will be a good reason for termination of the contract. So in the course of time, the original theory of implied term was rejected, but later on, now in 2009, they find that implied term actually is more to the finding of the intention of the parties. It is a matter of a construction. It still is relevant. But later on in the different case in Edmonton Commercial Corporation, the law has been revised and it has been changed, and they come up with the multifactorial theory that whenever someone has to decide on the event whether it can be whether it can frustrate the contract or not. It has to look at the multi factors. So this in fact modifies the original theory of impossibility of contract or the delivering of performance or performing the contract. So and this is the main development under the common law, and I mean, this is a little bit different from the Malaysian law. So when we come to the Malaysian law, in the Malaysian law, the guiding principle is stated in the section 57 of the Contract Act, and it is why it reflects illegality and the frustration doctrine, because under the Contract Act, the section 57 has three limbs, limb 1, 2, 3. First limb looks at the impossibility of delivering the subject matter at the time of contract, so that would be related to the non-existence of a consideration, and perhaps based on that principle, we can consider it to be to result in the voidability of contract. The relevant section that is, the relevant section to frustration doctrine under English law is subsection 2 and subsection 3. Now, subsection 2 and 3 cumulatively saying that a contract to do an act which after the contract is made becomes impossible, or by reason of some event which the promisor could not prevent and become unlawful, or becomes void when the act becomes impossible or unlawful. So it is very much close to the tailored case, the theory under the tailored case. We can see the law is drafted based on the tailored case, looking at the impossibility of delivering the subject matter. But then when we look at subsection 3, it looks at the self-induced frustration. It considers the reasonable diligence and foreseeability and the promise, or the knowledge of one party regarding to it. So together with all this section 2 and subsection 2 and subsection 3, we can state that there is a similarity between the force majeure theory of civil law and the frustration theory of English law or common law. So in both theories, externality of the event is considered, enforceability of the event is considered, and the irresistibility of the or the lack of taking some measure against it is considered. Yeah. So now that would be according to the Contract Act, but then we have our own case law. The first case that mentions the frustration theory regarding this matter, regarding the principle, is the Guan Ekmo Kuala Lumpur Sendirian Berhad. In this case, the court came up with the 3 criteria. One, for which no provision has been made in the contract. Yeah, the theory can apply in cases where the event is and for which the measure is not taken. The second is the party relying on the event must not be responsible for it. In other words, self-induced frustration is not recognized is an excuse for termination of contract. The third one is that the discharge of the promise after the event be radically different from the promise undertaken during conclusion of contract, and the court must find it unjust to enforce it. So perhaps the third restriction imposed by the court in this case is related to the development in common law and the radical change, and perhaps also subjecting the determination of force majeure the frustration theory to fairness to the parties. Yeah. So, and this one will be quite close again to the point which the early speaker mentioned. Yeah. Now, the radical change, the things undertaken would, if performing a different thing from that contracts for, you know, so the Davis contractors case has been the leading case on this point. Yeah. Now, if we look at the Malaysian case law, the events which are considered by the Malaysian law are the war, frustration comes into play after the contract is formed, is mentioned in the section 757(2). Destruction of the subject matter by fine, that one is the English case of Taylor on the point, and the non-occurrence of the event, which was also the case in the coronation case, that is a Krell versus Henry. Yeah. So the theory of frustration also extended to death and incapacity of the performing party, which can be either death or imprisonment, incapacity by imprisonment, that is already considered as an excuse for termination of contract. Statutory prohibition is recognized as long that prohibition is applicable and still active. And then inability of promisor to obtain license, again, it looks, it is a kind of not something that happened that is related to the delivery of subject matter, but rather than the legality of the contract. So, and then another one is acquisition by the government. So acquisition, if the property or the subject matter of the contract has been acquired by the government, that will be physically impossible for the promisor to deliver it to the promisee. So those are the cases or the incidents or the events that are recognized under the Malaysian law to fall within the doctrine of frustration. So the Malaysian law excludes from the doctrine of frustration difficulty in delivering the subject matter or performing the contract, or impracticability of the performance of a contract. So we have the cases on the right regarding that matter. Yeah, difficulty will include a long way to go on with. Expensive, you know, the delivery of the subject matter or the performance of the promise become expensive, and that is not so much radically changing from the original promise. If it was radically changed, then perhaps that will be under the come under the frustration theory. Foreseeable and resistible events where the Malaysian court has decided that they're not too strong a storm can be, you know, can fit within the doctrine of frustration theory. And then again, a contract that is not fundamentally changed, that cannot fit within the doctrine of frustration under the Malaysian law. We have the self-induced frustration also excluded. Foreseeability by one party at the time of contract is also considered, where compensation under section 57(3) are supposed to be provided by the party who is at fault, yeah, or to the party who has suffered the loss. So these are the important development under the Malaysian law and the doctrine of frustration. Now, the question is whether the COVID-19 can fall within those limitation and the impossibility of subject matter delivering the subject matter can fall under that or not. Of course, when we look generally, there is during the COVID period locked down by the government, making it illegal for anyone to move, to go out from their houses after a certain, within beyond a certain distance. And in the modern time, the thing is that most of the work can be done from home. So that is a factor that has to be considered. Then we also have the not so strong legislation, or no legislation rather than guidelines published by the government, which are mostly relevant, to the employment law. And at that point, they were just restating the position under the Employment Act, not more than that. Now, if there is any dispute in the future, COVID-19 cases would be subjected to the test of impossibility of the delivering of the performance, or the impossibility of performance of the obligation, not difficulty. Yeah. So not difficulty in a sense that at the end, if the promise is performed, it would not be a change from the original promise. And here under the common law, they say they use a simple test. They're saying that I did not promise that. Yeah, I did not commit myself to that. So if the result is in that sense, then it will be subjected to the theory or doctrine of frustration. Otherwise, it will not be qualified to come within the doctrine of frustration. Now, generally, again, when we look generally and reflect on the law and the matter, it may take some time for the parties to bring their cases to the court of law, and it will take some time for the courts to decide. That is the defect in the common law system, where justice is delayed. You may need, especially in the real estate, law, and especially in the for those who are in the construction business, delay every hour, every minute someone delays something, it costs them. So if a case in the civil courts takes 5 years, 4 years, 3 years, perhaps that is the maximum now, the target of the courts, it is still delay. By that time, perhaps the company who suffer because of the COVID, they may become bankrupt. So that is the thing that we have to consider. And those, because one thing we have to mention, because under the construction law, they are subjected to the guidelines from the PAM, and PAM normally—
Dr. Tahir, sorry to interrupt. You have 5 minutes left.
Oh, mashallah. Okay.
Yeah.
So under the real construction law, perhaps the construction, the force majeure clauses will be there, and that could have some effect on the dispute resolution among the parties. If they want to wait for the law, whether there is any legislative action, or whether there is a court decision, it may take some time. I think what I have to do is, perhaps I'm a little bit comparing civil law principle and common law principle to the Islamic law principle. And I find the Islamic law principle on the termination of contract is not so strict, not so limited to the force majeure event or the unexpected event. It looks at the risk, it looks at the loss, and the disruption of the terms of contract. If the disruption of the term of contract results into some risks or some loss to one party, the court sometimes the principles are sometimes the contract can be terminated, other time there could be some compensation. Now, in Islamic law, the compensation works in two ways. Anyone who suffers some loss because of a certain event, they have to be compensated. Yeah, so the compensation, or what they call it, compensation, is based on the sufferings, detriment to the parties. So in Islamic law, normally they look at the breach of term. If the term is cannot be fulfilled because it is possible to be fulfilled, then the contract will be void. They will look at the impossibility and difficulty of delivering the subject matter. So unlike common law, unlike common law or Malaysian law, Islamic law does not insist on impossibility. It also considers difficulty of delivering the subject matter. And of course, the force majeure in the strict sense is mentioned under the Roman law is not widely applicable. It only applies into the rental contracts and the agricultural contracts. So that may or sometimes the impossibility to deliver the subject matter. So these three principles under the Islamic law provide some kind of justice to those who have suffered because of one of the parties is unable to deliver what he was obliged to deliver. So I think if I have no time to explain these matters, I think I will conclude my speech on this, and I will suggest all those who are having the what they call it, force majeure clauses in their contract. They have to look whether those force majeure clauses are fair to both parties or not fair to both parties, whether there is an ambiguity on the terms of those or not, whether consent was given to those terms by both parties or if they were imposed on one party. So those can be subjected to dispute, but if both parties have negotiated the clause clearly, fairly, and perhaps the conclusion would be different. You have to remember, just now as a professor was saying, the freedom of contract in German law, freedom of contract under Malaysian law is there, but it is always subject to the provision of the statutory laws. So within the limits of law, parties have freedom to contract. The terms of the contract have to be fair within the scope of the given law. So law is always a guideline or something that defines the scope for the operation of contracts. So we don't have absolute freedom of contract, yeah, where parties are free to enter into a contract no matter how much the term of the contract are unfair or unequal to the party who is dominated by one of the other party. Yeah. So this, I think. Thank you very much. Assalamu alaikum warahmatullahi wabarakatuh.
Thanks a lot, Dr. Tahir, for sharing with us your experience as well, especially on the origin of the term force majeure. Basically, it came from French. Is essentially French.
Latin.
And
Latin.
Then, Latin. Okay, but it's, I think I read somewhere it comes. I mean, it's a French word, isn't it? A force majeure. So,
because Roman law had
Roman law. Okay. Yeah. And you mentioned about theories of frustration, and the most weighted part is the Malaysian law or perspective on especially in relation to Section 57 Contracts Act 1950, and then you conclude with some comparison aspect, okay? Comparison perspective on civil law, common law, as well as Islamic law. I think that's the niche area of IIUM, okay, wherever we try to harmonize the law, we try to make comparison wherever relevant. So now we want to open the session for question and answers, Q&A.
Mrs. Fadhilah,
Yeah.
May I
Yes, Prof. Stefan.
make some addition to the presentation, which is from the comparative aspect, maybe interesting?
Okay, yes, please,
Because
please, sir.
it's just very
Yeah.
short, because the
Yeah,
last
most
you
welcome.
mentioned about the frustration, it was very interesting for me to see that you make this contrapoint between frustration theory and the force majeure aspect. And it seems to me that this aspect of the session of the contractual basis we use and we developed from the bona fides principle is quite flexible. Very interesting.
Yes.
Also the parallel to the Islamic law. But let me mention one thing. We have a very clear dogmatic about when we have frustration of the contractual basis, so in this bona fides aspect, or when we have frustration in the sense of impossibility of performance of the contract. The impossibility of performance of the contract, I just want to mention that because it seems to me very instructive. We have in the section 275, which is impossibility of contracts, and we have something we call praktische Unmöglichkeit, practical impossibility. The obliger may refuse performance to the extent that performance requires expense and effort, which, taking into account the subject matter of the obligation and the requirements of good faith, is grossly disproportional to the interest of performance and of the obligee. Yeah. So this is what we call the practical, and it is important that it is only applied if the equilibrium of obligation is disturbed. So in the case you said about the construction, this was bringing me to that idea. When the price for the supplier gets higher and the court says this is not force majeure, we would check whether that is falling under this 275 Article 2, or whether it's falling under the 313 I mentioned in my presentation, which is leading to an adaptation of the contract because of the basis of the contract. Because if there is no change in the equilibrium, so the prices get higher, and so also the wish of the other contract partner gets also higher, because if the price higher, it's more attractive for the other one. So we have a clearly parallel development to the up. In contrary to the disturbance of the equilibrium, where we have the interest of the one part is same and the interest of the other one is higher because the price is very high and you want to change something, then we really have a clear differentiation between this frustration application of the frustration law, of the frustration impossibility, or of this bona fides application of the ending of the bath of the contract. It is very interesting for me because I think it was very surprising that it is more or less really ruled under this frustration theory. Thank you very much. It was from the comparative point very enlightening for me. That's
a lot, Prof. Stefan, yeah, for making clear explanation on that, on comparative aspect of it. We have around 20 minutes, okay, maximum, to have Q&A, question and answer session, because some of the audience here, I believe they all have some burning questions to be addressed to, or to be
we have a question of Mrs. Janet Lee already.
Yeah, can we respond to that first, Prof. Stefan? Maybe you want to respond on that? Or maybe Prof.
Is that
Dr. Tahir, you want to respond?
Let me just see. Maybe you can.
I can read it to you, the question.
Yes.
Yeah, I can read it to
Mrs.
everyone
Lee
here.
I cannot see good. It's very small here. Can you read it shortly?
Yeah, I'm reading it. Okay.
I see. All right. She wants to know whether the new Malaysian COVID-19 Act, similar to our Mitigation Act, which becomes law in July 2020, is still necessary because of the opportunity that we get soon a vaccine. Is that right?
Mm-hmm.
Don't we have
Meaning
the freedom?
Obviously,
she is very critical to a legislative change of also of the private autonomy. Well, that we get maybe a vaccination soon, and that the situation is more relaxed now. First of all, this is not so clear. There is a big area whether the legislator and the government can decide whether it is still serious or not. And even if we get a vaccination, this means that we have still the economical result of the pandemic before. So if we decide this was a heavy pandemic and it was heavy impact to the society and to the economy, I would say even if we have in the future a vaccination, it will not stop the reason for giving that legislation. The other part of the question, no, I also think we should use, as I mentioned in my presentation, more the flexible way in this contractual relationship, and maybe give some fiscal or other public help to the companies. I think this is the wrong way to at least to abandon the rights of the customers to get payment back, or the right of the contractual partner to get a counter payment in the contract.
Dr. Tahir, you want to add something, especially on Malaysian perspective? Do we need new law actually to cater for force majeure in Malaysia? Or can we just rely on existing laws, perhaps?
I consider the stand in Malaysian law under Contract Act, because this is a matter of Contract Act, no matter what is related to real estate, employment, and so on. It is all coming back to the Contract Act. And the Contract Act in Malaysia is very old. It really needs amendment. And especially if you relate it to the COVID-19 and the impossibility, perhaps the rule from impossibility should be, I know that the rule of impossibility should be revised. Perhaps it can switch to the possibility of risk sharing between the parties, rather than, at the moment it serves like a penalty for the person who did not perform contract due to COVID-19. Yeah, because the big issue is whether pandemics comes under the impossibility or not, because the difficulty issue has been decided by the case law. They don't want difficulty to be part of the frustration theory. So some unfairness, unfairness is there, and that unfairness perhaps needs to be removed. And perhaps a good principle for mitigation of the risks has to be considered. That I can see at the moment.
Okay, thanks, Dr. Tahir. We have more questions coming up.
Okay.
The next question is in the chat box. Okay, are we allowed to use frustration when force majeure fails? Or are we allowed to use frustration only when there is no force majeure term in your contract? So how do we answer that? I
presume I have to start first.
Yeah.
As I mentioned earlier, force majeure is the principle under civil law, but equivalent to that theory is the frustration theory. So if you look just now, when I was comparing the elements of force majeure, the impossibility, unforeseeability, and irresistibility, the three principles under force majeure are available under the frustration theory. So, frustration theory is covering force majeure, but the problem is whether certain thing is really a force majeure or not. That one is not clear. If it is really beyond the foreseeability of the parties, then it can come within the doctrine of frustration. But if it is beyond their foreseeability, yeah, it is within their foreseeability, then the contract will not be terminated. The party has to pay compensation for any loss if there is any loss.
Okay, thanks, Dr. Tahir. I think there's one question from Dr. Loganathan. Dr. Loga, you want to ask question now? Verbal questions.
Yeah, hi. Good morning. My question is, in addition to 57.2 of the Contracts Act, we also have Section 15 of the Civil Law Act, which allows the payment which is paid to be refunded, payment payable to be ceased to be payable, and there is a proviso to the which says that if the party who is being alleged to be at fault have incurred any expenses, the court will determine a certain amount out of which the amount is being paid to be retained. My question to Dr. Tahir is, will that provision be sufficient to claim that there is some form of element of solidarity, justice between both parties? Because I think 57.2 and 66 may not be adequate to deal with it. So that is my question. Thank you.
Thanks, Dr. Loga. Dr. Tahir, your response.
Okay, I will suggest the Malaysian law have to move more to the German perspective rather than common law perspective, because in German law the risk is taken and the sharing of risk is considered. So I presume that if we want to improve on the remedy for the parties, it has to be based on sharing of the risk between the parties. On the matter of solidarity, what happens in Malaysia and other countries, the government stepped in. The government provided certain remedies to those parties who have suffered because of the COVID-19. But that one is not matter of solidarity. It is rather than matter of public, what do you call it? Public intervention from
collective solidarity.
Yeah. So it is a kind of bailing out the party who suffer because of the pandemic.
Very interesting is that we are not subsumize the most of these cases. We would not subsumize it under the frustration theory in the German law. Because the cases I mentioned, that in the rent cannot be paid, or the airline will not pay back the reimbursement for the ticket cost, these are all not question of frustration for us, because it's not impossible. It's not subjective impossible, and it's not objective impossible. So it is just a question really of the bona fides, yeah, whether we can stop this obligation, or we have to adapt this obligation to say one of the contract party, okay, there is a certain situation, you will not get the money back. Sorry, it's bad luck. Yeah. So and this is again, as Mr. Tahir said, this is again a question of the risk allocation, whether we want that or whether we don't want that, or whether we should have a remedy by state measurements, like help to companies, so we can avoid this distribution to the customer. Because one thing is clear, there is two options, or the state is financing the airlines use the money from the state to pay back the ticket cost, for example, and then we internalize the risk to the state, and so to the society, or we say no, the state will not finance the airlines and help the airlines by giving them the right to keep the money and not pay back the money, and so they will not get bankrupt because of these claims of the customers. But in my opinion, it must be a clear decision which way it should be gone. And in my opinion, the second way is not the right way. So if we have the decision that the state should finance this risk, then the state must finance this risk and cannot additionally say to the customer, you will not get the money back. So this is all not for us, not a question of the frustration, because the equilibrium relation is the same. The customer has even a bigger interest to get the money back due to the pandemic, and the company has even a bigger interest not to pay. But the relation between these two interest points is constant. Yeah, this is really very interesting. Because I think the common law is very static in this, right? You have the force majeure clause in the contract. When that is not the case, then you analyze whether it's under the frustration theory. And many of the cases we would not do under the frustration theory. You do under the frustration theory. This is a big difference to the civil law, as you already mentioned.
Thanks. Yeah.
If I can add some point from Islamic law. In the Islamic law, whenever there is a contract, the consideration should be on equal terms. So if as a result of pandemic, one person suffers and the other party gains or have the same position, then the equilibrium, they call it masawat, or the equality of consideration, is lost. So based on that one, what I'm proposing here, because contract is a personal matter, it should be settled between the parties, not the government should not be brought in all the time. Whenever the governments come in, it is perhaps a good act on part of the government to come up come in this situation. But because contract is personal matter, we have to look at contractual principles, and the contractual principle under Islamic law are based on the equality of consideration, or perhaps under common law, unjust enrichment. Unjust enrichment under the contract law, if you allow one party to gain more, other party to lose more, then perhaps the extra gain could be unjust and unfair. And this is where the Malaysian law says if you have to look at the consequence of the case, whether it is fair to the parties or not. The fairness is the element that is considered by the Malaysian courts. And if you compare it with Islamic law, then that equilibrium or the masawat or the equality of consideration has to be taken into consideration.
Thanks, Dr. Tahir. We want to allow some of our students to ask questions. Okay, I believe they all have so many questions with them. So anyone want to ask question from my class, Dr. Soni's class, Dr. Tahir's class, or anyone, students? Since you all have done your frustration topic with your lecturer or even with myself, so any questions to be asked to Prof. Stefan or even Dr. Tahir? Anyone? Kuratul Huda, are you still around? Sabina, please ask question. Those are my students. Or open to anyone, to the whole audience. We have roughly 90 plus audience today, which is good. Participants.
Where is James? James has around? Or
Yeah,
James is around or gone?
I'm not sure. Cannot see him. James, are you still around? Mr. James.
I think he was telling me that he has some class or something.
Yeah.
Dr. Suzi, can you also inform the crowd about the participation registration?
Okay, all right. Dr. Soni has put the link in the chat box. So please click the correct link. Okay? If you are from section 1 students, so click the link. And then for the rest of participants, okay, we provide e-certificates. So please click on the link and fill up the details, and it will be emailed to you later. So the email is in the chat box. So you can have a look at the chat box, okay? Click the link because we are towards the ending of the program for today. Okay, our webinar is ending soon. We are waiting for any more burning questions perhaps from the participants here. Please make full use of our Q&A session. Any more coming questions? So Dr. Tahir, how to resolve the issues pertaining to flight ticket cancellation in Malaysia? Because Prof. Stefan was sharing his experience, what to do, or actually there's no solution yet. So what's in Malaysia? Can we sue airlines, okay, for denying our refund? Okay, they decline to refund us actually.
So
what do you think?
We go back to the original principle. Is the contract performable or not performable? If the contract is non-performable, but perhaps they have some excuse. But if the contract is still enforceable and it does not come within the frustration theory, and yet they did not provide the flight, then they are in breach of the contract. So the restitution under Section 66 should be there.
Okay.
You know,
Right.
In the European law, it's very clear. Article 8 of the regulation on passenger rights says, in any case, if there is cancellation, then the airline has to reimburse the ticket full, including the taxes, everything. Another question is the claim for a certain damage, which is also possible. There is also a claim against airlines if the airline is not conducting the flight or the flight is delayed. And here we indeed use also force majeure. In case of force majeure, for example, in an airport, there is they are in an outstanding of the work, no one works there, and then they cannot land or something like this. This is force majeure, höhere Gewalt, and in that case, the airline does not have to pay damage repair. But still, the airline must reimburse the full ticket cost, even if there is force majeure. The question here is, the most interesting question is here whether you can change also this by a question of bona fides, yeah. So that this right to get reimbursement is also a way, and yeah, we see, in my opinion, this is not possible. and it must be decided on the bona fides principle.
On the German part, the law is clear, but in Malaysia, the law is a common law,
It's not clear.
and
It's
the law
harmonized
is
in all Europe. Yeah.
Yes.
Yeah.
So the thing is, in under the German law or under the European law, this case can be brought in within the force majeure, but it will be difficult to bring it under Malaysian law.
But careful, actually, in the normal frustration theory, it's also actually clear. If the contract is not fulfilled, there is no right to get the counter payment, right? So if the company is not giving me the product, I don't have to pay. And that is actually a general, I think this is also in Malaysia like this, yeah? But whether they have to pay back or not because of the pandemic, this is totally not clear. This is
exactly, it's not clear.
Yeah, it's not clear. Any more questions coming up? We can allow 1 or 2 more questions before we conclude our session for today. Seems no more question in the chat box as well. So hopefully, I mean, you have gained some exposure, additional knowledge in relation to force majeure and contract law, pandemic, and what more, what not. And we would like to thanks everyone for participating, for attending our sessions for today. I have learned a lot actually, as for myself, especially for my contract law course. I'm teaching advanced contract law as well. So this is a really advanced part of contract law. And then I think we prepare recording of the session as well in case you want to review or you want to use it later, for your future references. So I'll pass back the session to Dr. Sony as the administrator. Sony, are you there?
Can you give me back the host for that we can use the room next time? I don't know if you don't give me the host, maybe then in September I cannot open it. So
okay, I will stay just for a few minutes after the ending of this. Then we settle.
And another question: can you somehow make me downloadable the record of the last session and this session, because I also want to upload it for my students?
Okay, sure. We will deal with that very soon. After this, I'm just doing the closing of this event. So thank you, Dr. Suzi, for moderating the event. Thank you
very much.
The speakers,
thank you very much.
Stefan and Dr. Mohammad Tahir. Thank you, Prof. Bone, who has been with us also from Dortmund University of Sciences, Applied Sciences and Arts. Thank you, all the participants.
He's near the pool.
Yeah, he's there?
Near the swimming pool in the middle of the night.
Oh, yeah.
Yes, thank you very much.
That's true, very true.
Thank you very much for all. This is great moderation.
Yeah, thank you for all the participants, both from IIUM and outside IIUM. Also, we have some from Indonesia, Jakarta, also Binus University has been there for some of them. Prof. Siddhartha, Dr. Abdul Rashid and all. So we have few friends also from outside IIUM and outside Malaysia. That is good. So we are welcoming you back to the next series of webinar. If you can see my background here, I'm being invisible again. So you can see it is there. We are going to have another 2 seminar in the future, and it's going to be in September, inshallah. So we will be back and till see you again. So thank you, everyone. I hope you all enjoy. Assalamualaikum warahmatullahi wabarakatuh.
Thank you.
Thank you very much.
Thank you.
You're welcome.
Thank you, Dr. Suzi. I forgot to mention.
A lot. My pleasure. Bye, everyone.
Okay.
Bye, everyone. And thank you very much for.
Make sure everyone, especially my class, to sign up for your attendance. All right. Ya, Dr. Abdul Rashid dari Jakarta, Binus. Terima kasih.
You're welcome.
Dokter, Assalamualaikum.
Prof. Stefan, you recognize Dr. Abdul Rashid? Must be, he's somewhere. So, Dr.
I think he's not in anymore.
He left already, I think.
Yeah. Dr. Abdul Rashid is our alumni as well, PhD in AIKOL. So, thank you for being with us. And everyone, I see some friends from Uttar, Miss Janet, Miss Logan, Nathan, perhaps from Uttar as well. Yeah?
Yes.
Is that correct?
Yep.
I can see my student, quite a lot of them.
There was a
Not
good
sure
crowd.
how many of my students make it to the session today, but a number of them.
Yeah, a number of them is.
Yeah, there was a good crowd. Even without, without my replacement class, it would be over 50 already. So.
Mr. Tahir, I want your slide. Email me your slide. Very interesting. Very useful.
Okay. Because